Religious freedom experts say that it is possible that President-elect Donald Trump will reverse the State Department's efforts to push gender ideology and abortion. The moves would come after the inauguration next month. Under the Biden administration, officials have used the State Department to promote transgenderism and gender ideology through government grants. The Biden White House also ended policies that banned funding for foreign organizations that promote abortion. All this comes the day after the Supreme Court heard arguments in the case the United States versus Skrmetti. The case centers around Tennessee's law SB 1, which bans so-called gender-affirming care for minors. Tennessee Attorney General Jonathan Skrmetti published an op-ed today in the Tennessean saying in part, quote, puberty blockers, hormone treatments, and sex reassignment surgeries are off limits to kids in Tennessee. That is the same common sense approach we take with tattoos, alcohol, and tobacco purchases and other consequential decisions. Yet now the federal government argues this age-conscious protection amounts to illegal discrimination. And joining us now is Jonathan Skrmetti, the Attorney General of Tennessee. Sir, thank you so much for coming on today. We appreciate it. Before we get to your op-ed, I want to get your thoughts on what happened at the Supreme Court on Wednesday.
Well, you never want to make predictions, and there are months and months to go before the justices finalize a decision. But there were two things that I thought were worth noting. The first is it was a long argument. There were a lot of questions asked. The justices probed a number of different areas that are significant. The second thing is I was very pleased with the way our case went in. My Solicitor General, Matt Rice, did the argument. He did a terrific job. I was really proud of the briefing that we were able to put together for this case. And so I don't know what the court's going to do, but I feel very good that we have done everything we possibly can to advocate forcefully and effectively for Tennessee's position.
Yeah, and I want to talk about that op-ed that you put out today. In it, you say this is an issue about protection of minors. Meanwhile, those on the other side say it's about discrimination. What would you say to that?
I think if you look at the record of the legislative proceedings that led to this law, in which the Tennessee General Assembly very carefully considered evidence, heard testimony, looked at developments elsewhere, it was purely focused on kids. The research that they looked at was focused on the very serious risks to kids of significant lifelong complications. The discrimination angle is based on a reading of our sex discrimination laws that I think just doesn't really squarely apply here.
Yeah, and another question that came up is whether the Supreme Court should even be deciding this case. Here's a clip from Chief Justice Roberts. Let's take a listen.
Here, it seems to me that the medical issues are much more heavily involved than in many of the cases that you look to. And of course, we are not the best situated to address issues like that.
Mr. Attorney General, your thoughts on this?
I mean, I think that is the fundamental principle of constitutional separation of powers being articulated there, which is the courts don't make the law. The courts don't tell us what the right outcome is. They ensure that the Constitution is followed, but most of the authority to make decisions lies closer to the people.
Yeah, and I want to talk again about protecting children, which you mentioned in your op-ed. You also cite developments in Europe, saying, quote, after careful review of the research, the medical communities that pioneered gender interventions for minors have pushed for restrictions because of new evidence. Now, during the hearings, scientific arguments were made in defense of the ban, but Justice Ketanji Brown Jackson said that science was being used in the same way that was used 60 years ago to defend bans on interracial marriage. How would you respond to that one?
So I think what Justice Jackson, and I don't want to put words in her mouth, but I think the line of questioning that she was pursuing was focused on the idea that if you have two separate people within a category and you treat them differently, then you're necessarily discriminating on the basis of that category. So she was drawing an analogy between racial discrimination and sex discrimination. But the difference is this is not simply a matter of distributing, say, testosterone. It's not that boys can get testosterone and girls can't. Anytime you prescribe drugs for a medical condition, you look not just at what the drug is, but what the condition is. If you give a boy testosterone, who has a testosterone deficiency, it cures that condition and reduces future medical problems. If you give a girl with gender dysphoria, which is a psychological condition, the same testosterone, it creates a host of medical complications. So it's not a comparison of like to like here.
And we're going to leave it right there. Mr. Attorney General, thank you so much. We appreciate it. God bless.
Thank you. God bless you.